welcome to June the 9th, 2020. It's a Tuesday, a wonderful Tuesday at that. We are very lucky to have with us some very big fish. Very big fish in the sense that they are giants in the areas in which they want to give us some exciting lectures for our course AC 814 and for our course AC 914. AC 814 for master students and AC 914 for the doctoral students. Both courses carry the same title, Principles and Practice of Entrepreneurship. The master students take some content that is lighter loaded than the doctoral students. Our agenda for today, you will see today, June the 9th. We're going to have a first live lecture on entrepreneurship and intellectual property protection, after which we're going to have another lecture on entrepreneurial opportunities in science, technology, engineering, and mathematics. Now, I want to welcome our first facilitator. Who is our first facilitator? He's Professor Adebambo, Adewopo, SAN. For the benefit of those who are not Nigerians, our participants from Ghana, from Burundi, from DRC, I'm sure that our professor from Sierra Leone is aware of this high title, highly, very coveted, position in the legal sector in Nigeria. Is the highest. Is the highest in the land. So Professor Adebambo, Adewopo, SAN. Let's have a short introduction of him. He's a leading academic and practitioner in the field of intellectual property, IP. You see, we are hoping, we have a course. The course is cultural techno-contextual approach, on which the delivery of our courses in this center is based, and it's helping to help us patent that invention. So he's currently professor of law at the Nigerian Institute of Advanced Legal Studies. He's a senior advocate of Nigeria, as I said, the highest in the land. To earn senior advocate, ladies and gentlemen, it's like the camel through the eye of the needle. So this is a great man indeed. Prior to taking the intellectual property chair at the institute, he served as the Director General of the Nigerian Copyright Commission. I need to pause here to let you know that while he was Director General of the Nigerian Copyright Commission, every crook that will want to subvert the copyright law in Nigeria was caged. Every crook. All those people who are pirating software, pirating films, and all that, if they hear Adewopo, they will run inside a well. So he remains one of the most successful Directors General of the Nigerian Copyright Commission and a great enforcer of the law of the copyright law. Prior to that, he pioneered teaching and research in intellectual property at the Faculty of Law, Lagos State University. He's a past fellow of Max Planck Institute for Intellectual Property in Munich and the Center for Intellectual Property and IT, University of Edinburgh. He's a fellow and consultant of Open Africa Innovation Research, and that's the largest Pan-African intellectual property research network. In association with University of Ottawa and University of Cape Town in South Africa. Now, I like this next sentence. His published works in the field are countless. Now, meaning that when you count up to 300, when you get up to 300, they become countless. So, Professor Adewopo, we are very proud of you for your scholarship in the area of intellectual property, specifically, and in law, generally. He has served in various roles at the World Intellectual Property Organization, including tutor, distance learning center, WIPO Academy, Standing Committee of Copyright and Related Rights, and head of delegation of Government of Nigeria, among others. Now, recently, it was Nigeria's nomination for the office of Director General of this organization, the World Intellectual Property Organization. Don't worry, sir. God will do this for us. You're going to be DG of this World Intellectual Property Organization. He's a member of the Chartered Institute of Arbitrators, UK. It's now my pleasure. Oh, yeah. Still more. Still more. Adewopo attended the University of Maiduguri, University of Lagos, and University of New Hampshire. Franklin Pierce IP Center, USA. Is a partner and is a partner at L&A Legal Consultants. It's my pleasure for me on behalf of the 88 students and facilitators from all over Africa. Facilitators include renowned professors from Nigeria, from Europe, from North America, and former vice chancellors and 7 vice chancellors. I saw that Professor Adebambo walked in a few minutes ago to give us a lecture on entrepreneurship and intellectual property protection. Professor Adebambo, Adewopo, SAN, you now have the floor, sir.
You remain our leader and our mentor. I want to.
Do you want to share your? Do you want to share your? You want to put on your video? We can't see you.
Okay, I will do that as I'm talking, sir.
Yes, sir.
It's my pleasure.
No, we have to see your video right now. We have to see your video because I'm recording at the back end.
To be here, to be a facilitator for this very distinguished audience. It's really my pleasure, particularly on a subject that is of critical importance in the current global development. And I believe that Nigeria should not be an exception. And I'm really happy that Prof thought it wise to introduce this subject in the curriculum of this particular program. At the end of this hour, it is my confidence that you will have more than a basic understanding of the concept of intellectual property. That is my assurance to you. This is what I call a masterclass. Although we don't have much time, I'll be very fast, if you pardon me, because I have you have the slides. So as I run through the slide, I may or may not go page by page, but I will just speak along to save our time. So you will not only have more than a basic understanding of the concept of intellectual property, but also its application to your primary discipline, in addition to the idea of entrepreneurship, which has been encapsulated in the title of the course, Entrepreneurship and IP. Very quickly, there are 4 segments. Like I said, I will not go through the slide by slide, because that is going to actually draw me back. You have the slide, but again, I will still refer to some slides and all of that. But I need to point that out so that we can be fast because of time. So at the end of the hour, like I said, I will assure you that you will have not only more than a basic understanding of the concept of IP. I will use IP for short. Intellectual property is a bit mouth-filling, so I will just use IP, and I will understand that you get what I mean by IP. That's the acronym for intellectual property. But also its application to your primary discipline, like I said, in addition to the idea of entrepreneurship, which is the subject part of the issues here. There are 4 parts. We're already in introduction. I would like to introduce us to the key concepts, which I believe will lay a background, a foundation from which we can proceed into the nitty-gritty of the subject of IP. Then we'll dive straight into IP protection, and under IP protection, we will discuss the legal categories of IP, and we'll also look at the legal framework. Never mind the idea of legal, I will make it as simple as we can, because I know we're not lawyers, neither are we law students. But because IP is a legal framework, it's a policy and legal framework, it doesn't mean that non-lawyers are not involved in that subject, particularly as entrepreneurs, innovators, creators, scientists, as the case may be. Now I have a bonus for you, which is the last part that I have called IP asset management. That's my bonus for you. I teach a course, the only course in this part of the world where this subject is taught, IP asset management, basically for IP managers, scientists, and innovators. So that is a bonus that I will throw your way in the course of as a concluding part. Part of the introduction is for me to say that the concept of entrepreneurship and IP are not confined to any particular field of knowledge or discipline. And so that's, and I must really commend our distinguished professor and mentor, Professor Bukola, for this vision and insight, because it's not something that is common knowledge, even by our curriculum developers in this part of the world. I remember several years ago, almost 20 years ago, I was going to teach IP to engineering students in LASU before I took a leave of absence. So it's not confined to a particular field of study. I believe that MBA students, postgraduate students in every field should have a basic idea of IP, because we're in the age of knowledge, when the global economy is knowledge driven, and this is something that is a very useful tool at this time. We've seen successful entrepreneurs who have been seen to be engineers, scientists, medical doctors. That is all over the place, and we're all aware of that. So it's important for us to know that. So we're not in a strange land, even though IP may sound esoteric, but it's something that I believe that all of us should have a basic idea. Now, it is multidisciplinary. And that's why there's need to teach it, beyond law. You find most of the IP experts, particularly in the developing world, as lawyers, but outside the country, most experts in IP are not necessarily lawyers. They are managers, accountants. You have brand managers, you have IP managers, you have IP directors in corporate organizations who have huge IP portfolio. So it's not a one field or one discipline. It's not confined to one field. It is multidisciplinary in nature and scope. And that again aligns it to the idea, to the rapidly, expanding function of university or tertiary education, not just as an institution for teaching and research, but also for entrepreneurship and for development. So it sits well in this kind of forum. That is the point that I am making, ladies and gentlemen. So let's go into the concept. Entrepreneurship, I believe there are more experts in entrepreneurship that will do better job than me in this area. But I think it's important to have a conceptual knowledge. That is something that I believe all of us should have. There are many definitions from literature, but there's no single universal definition for this idea or this concept. I have here presented to you different definitions. You see that on the screen. The one I like really most is that it's a process of creating a new enterprise or sustaining an existing enterprise with attendant risk and benefits. And that's very simple. Very simple. And I can bring out key features in that definition. The first one is discovery of opportunity. The second one is profit making. The third one is wealth creation. The fourth one is risk. And of course, with the attendant risk management. The fifth one is value creation or addition. It creates value and value added. And the other one is invention and innovation. That is where I am going. That is where we are going to connect this concept to IP, invention and innovation. So the question that will arise from that, from the identification of that feature, will be what is innovation? Because the linkage between entrepreneurship an IP is innovation. Every entrepreneur must innovate, must be able to create that opportunity, sustain that opportunity, and innovate. So the question will be, what is innovation? Like entrepreneurship also, it has many, many definitions, which you will find in literature, but because of time and space, there's a definition which I've used over the years by UK government. Innovation is the successful exploitation of new ideas. So look at the word successful. If you're not successful, you haven't gone beyond the realm of invention. You haven't gone beyond the realm of ideas into innovation. So that's that. Exploitation of new ideas. Exploitation is very key. New ideas is very key. As you see in a few minutes, that we're going to go through this idea of IP. Innovation is a powerful force of human nature. Innovation creates new business, cultural movements, social institutions, destroys, replaces, and leads. There is a concept of creative destruction in the cycle of innovation, disruption, where new ideas are created and the existing ones are left behind. Innovation feeds on the known and converts it into new ideas. So let's go for that. There are 3 stages innovation cycle, and you can see that in the last word of that. Individual creativity, which is the creative work. You have social adoption, where it is adopted, like you have a new invention. For instance, a new method of drilling oil. That's a new idea, but that has to be socially adopted. That has to be patented, and it is that innovation that brings it beyond the realm of invention. And of course, there's access to knowledge. In other words, there is a build-on technology for renewal, for improvement on that particular technology, as the case may be. So those are the underlying things in IP, as you will see them when we go further. So we go into the nitty-gritty, the core area of IP. And we'll start with the concept. IP represents the core of creativity and innovation. And it is what conveys or translates ideas into what you call IP assets or IP or knowledge assets. So IP is the invisible infrastructure of innovation. It is the hidden wealth that is worth several millions of dollars and naira. Most of the global brands today, their worth or their net worth is not sometimes monetary. It's in the goodwill, it's in the intangible property, it's in the IP that they have created. And you have new creations in different fields, and this is inexhaustible. In publishing, different titles, or what you call the catalog or the repertoire of the publisher, music, film, computer software. We're in the age of computer software today. Software creating different solutions, technological solutions, and different ways of resolving different tasks across industries. Household goods, fashion, pharmaceuticals, biotechnology, even the telecoms industry. So there are many fields in which IP has formed the economic foundation, the base, the economic base of the industry. And of course, I've cited different examples of IP here. Things Fall Apart, one of the best, the most well-known out of Africa. Hello is a song by Lionel Richie that has brought them fame and fortune. There's a Hello by Lionel Richie, there's Hello by Adele, many years after. And that is the intangible assets that these singers has helped these singers or these artists to be famous and of course to be rich as well. Sweet Mother, we all know that song, very evergreen. And there are also brands that I've also listed here without even going through the number. These are notable brands whose worth is not just in the infrastructure, as the case may be, but it's in the IP assets that they constitute and they convey in the marketplace. Now, IP, as we have said, is the legal rights which result from intellectual activities in industry, across industry, scientific, technological, literary, artistic, as the case may be. It aims, the law, IP law aims at safeguarding creators and other producers of intellectual goods by granting them time-limited rights to control the use made of that production. That's a definition that is very, very often cited, most cited definition, of course, of IP provided by WIPO, the Global Agency for the Protection, for Global Promotion and Protection of IP. So IP law is basically a legal mechanism or legal framework for the promotion, for the management, for the protection of knowledge assets. And the regulation of rights over those assets, because the law confers on those assets or on the creators of those assets certain rights that are regulated by the law. So that's very important. And you see the nature of IP here is proprietary, it is a property. Hence, IP, intellectual property, is exclusive in nature. In other words, it's exclusive to the creator. And I will come to that shortly, which is a term that is very technical. It's called exclusive rights of the author, exclusive rights of the creator, exclusive rights of the inventor, as the case may be. It's also negative in the sense that it is a right against the rest of the world, against the third party. It is intangible. It is time limited. You can see that, and I will also make big allusions to that very shortly. It's for some period of time. Copyright is the longest of all the other ones, and of course, trademark too is always longer. Patent is the shortest. It's conferred by law, usually statutory. So every country has its IP statutes or IP law, as it is. I had mentioned that it's a bundle of rights, exclusive rights. It's a bundle of rights. IP is a bundle of rights. I would like you, moving out of that class, to use that terminology and to show your more than basic understanding of this idea. It is a bundle of rights. It's a body of rights. It's a collection of rights.
Of course.
And it's both national and international. So there is, as countries have the IP laws, of course, you also have IP laws at the international level. You have the conventions, treaties that countries accede to that protects their intellectual property rights. Of course, it's also a private right, as very obviously, you will know that it's a private right. But there's always that public right versus public interest debate in IP. And that is something that is very important for our basic understanding. One of the goals of IP is not just to reward private creators or innovators, but also for public interest. If you patent a particular invention, there is public interest involved. For instance, in the current COVID environment, there is a search for vaccines. There's a public interest in making the vaccines available to the world, even though the rights of the pharmaceuticals or the patency of that vaccine is protected by IP law. That is probably the most classical and current example I can make in that. There's a whole lot of debate on that, but don't let's go into that. So you can see from entrepreneurship to innovation and to IP. Now let's go very quickly to the next level, which will be the legal categories. And I really like you to pay particular attention to this part. Again, that is the kind of diving slightly deeper into the subject. There are two broad types or categories or classifications or branches, howsoever we want to term them, of IP. The first is copyright, which of course we use every time, even as academicians. We use copyright without having the technical knowledge because the technical term is a term of art. Without having the technical knowledge of what the term conveys, there's copyright. And a copyright is original creation, original intellectual creation, but it's limited to certain fields. And that's very important for us to know. And the most classical of copyright from the history of copyright are these rights that I've outlined here: literary, artistic, musical works. They are called the classical works. In the history of copyright, that is where copyright actually began about 2 centuries ago, from the advent of printing technology. Literary works artistic work, musical works are what we call the classical copyright works. They are the works that are eligible. And this is captured in our copyright law, as it is in copyright laws of several countries as well. Then the second level, or the second branch of copyright is, or are, sound recording, cinematography, broadcast. These are called entrepreneurial works. No wonder, without even knowing this, Prof has already brought this into the entrepreneurship and IP. This is absolutely correct. These are entrepreneurial because of the application of entrepreneurship. Not that the classical works are not entrepreneurial, but those are the original works that copyright is conferred on. So that's why they are called classical. But the second layer, sound recording, and these are huge industries in themselves. Each of these works that are eligible for copyright are industries themselves. We talk about the music industry in Nigeria today, of course, we all know. We talk about the publishing industry in Nigeria today. We talk about the theater, we talk about the arts. We talk about culture, we talk about the film industry, we talk about the broadcast industry. These are industries that heavily, emphasis on the word, heavily rely on copyright or intellectual property protection for their sustenance. Then there is what is called neighboring rights. In some texts, you will see them, you see referred to as allied rights. In some texts, you see referred to as related rights. And this is expression of folklore, live performances. Folklore, of course, is a product of our culture, and we have to fight very hard to integrate this creative enterprise into the family of copyright. It has not been accepted fully. That is why it's called neighboring. It's in the neighborhood of copyright, or what is called para-copyright. But the same rights, the same bundle of rights attached to that work. Then we have live performance, which is the shows that the artists perform, live performance of those shows, or stage performance of stagecraft or stage plays. The reason why live performance has not been protected for is that I will come to, if you look at the eligibility condition, and if you look at the second one, I will explain that more when I come to that. Don't let me jump the gun here. So let's go to the eligibility condition. These are the conditions that all of these works must satisfy before copyright is conferred on them. Interesting. The first one is originality. The works must be original. If the work is not original, there is no copyright in it. And this brings me to the concept, which I would like you to write down. It's not on that slide. It's called idea expression dichotomy. That is a technical concept in the determination of originality of copyright works. It means that ideas are not necessarily, in fact, they are not protected per se. It is the expression of that idea that is protected by copyright. Very much unlike patent, and we'll come to that. Idea per se, in other words, if I have a particular idea, and that is important for the purpose of innovation. Everybody can have the same idea, but you have to translate that idea. You have to reduce that idea into a tangible form of expression. You can have an idea, for instance, a fiction, an idea to write a story, and if that story is not written, there's no copyright. If the story is in your head, there's no copyright. And you can have the same idea. You can convey the same idea, but it's in the expression, in the different expression. Maybe that idea has been expressed in form of stage play. That idea may have been expressed in form of film. That idea, the same idea may have been conveyed in music, in musical work. It is in those categories, those characterizations, that copyright attaches.
We have 10 more minutes, sir. 10 more minutes.
Oh my God.
Yeah.
You see that? Fixation, it must be fixed in a definite medium of expression. And I will have to be very fast. Industrial property is the second category. Trademarks, logos, marks, names, signs, symbols, patent, inventions, comprising process and products. And we have designs, which is a combination of lines. Then you have other types, trade secret, utility models. Industrial property category, trademark, patent, designs, they are registrable. Copyright is not registrable. In other words, once you create that idea, once you publish that idea, copyright is automatic. Unlike trademark, when you have to register it. Now, the key concept in trademark is distinctiveness. Just like you have originality in copyright, the trademark must be distinctive. It must be distinctive of that particular goods and services. There are other emerging new forms of IP, biotechnology field, in traditional knowledge, traditional medicinal knowledge, for instance, artificial intelligence is the most current and topical issue in IP today. The rationale for justification of IP, it provides incentive, it satisfies the principle of moral rights, it helps to facilitate transfer of innovation or knowledge, it facilitates investment in innovation, it promotes disclosure of proprietary information, it supports industrial policy, and all of that. I'm not going to go into that because there's so much ahead of us that I have to do in 10 minutes. Now, legal protection, which is the last part. Now, there are four basic framework in all the legal or policy frameworks that protects IP. The first is the subject matter. We have already identified that the subject matters, which is copyright, is either copyright or trademark or patent or designs. So these are the subject matter. And these are the subject matter that are eligible for protection. Literary works, musical works. In trademarks, you have logos, you have names, as you may create as a label on your goods or products as the case may be. And for patent, it's your invention. That is the subject matter. It's important for us to define the subject matter, which we have already defined. Then I mentioned exclusive rights, the whole bundle of exclusive rights that attach to those subject matter. For instance, there is a right of reproduction. An author will prevent a third party from reproducing his work. So that's called reproduction right. It will prevent another party from selling his products. That is an economic right. So there's a whole bundle of rights. Translation rights, for instance, for authors. That is your right in copyright. Adaptation right, to adapt your work to another genre of literature. That's another right. So it's a whole bundle of exclusive rights, which we cannot exhaust now. Then there's always a framework for administration, for administering those rights, or those subject matter as the case may be it copyright, be it trademark, be it patent. And those framework is either individual, public, or collective. If it's individual, it means it is by the right owner. The right owner will establish his own policy, and that's the bonus that I will shortly go into the last 2-3 minutes. So that's the individual protection mechanism or administration mechanism. For instance, encryption today through digital technology, you can encrypt your work in order to prohibit or restrict access to your work. That is an individual management mechanism. Then you have the public administration, where usually the law establishes an agency. In the case of copyright, you have the Copyright Commission that is responsible for helping the industry protect and enforce their intellectual property works. You also have trademark registry, where you can register your trademark. You have the patent registry, where they can grant you patent for your invention. Then, of course, you have what we call collective. It's an agglomeration of authors and creators in a way of something like a union, something like an association, whereby they come together to promote and protect their works collectively. And you must have heard about collective society in the music industry. That's a classical example of collective management. And of course, enforcement, to enforce those rights, is the primary responsibility of the creators to enforce their rights in the marketplace. Of course, with the support of states, when you have a large-scale infringement, whether in the form of piracy or counterfeiting, as the case may be. And those are the three laws that constitute the legal framework for protection of intellectual property in Nigeria. Copyright Act, 1988, as amended. Trademark Act, 1965, as amended. Patent and Designs Act, 1970. Those are the three stands on which IP stands today. There's something I want to bring out to you very quickly, and this is going to really cap your understanding. Now, if you recall very briefly, I was mentioning originality when I was discussing copyright. Sure. When I mentioned trademark, I was mentioning distinctiveness of the mark from one trader to another, from one producer of goods to another. That mark will be distinctive. In other words, you can have products for the same thing. Pure water, for instance, you have Ragolis, you have Swan, you have Pure Life, manufactured or produced by different manufacturers. Each of them must be distinctive for that good. So it's not about selling water, but you want your own water, your own package water different from another. That's distinctiveness in trademark law. In patent, the invention must be new. It's called novelty. Now, if you convey those elements, they all convey, they have a common denominator. That denomination is innovation, defined in the different context of each and particular IP, so copyright, trademark, patent, as the case may be. And I think it's something that you should stick to, especially when you're consulting a lawyer, as the case may be, when you're establishing a business, as the case may be. So IP assets are unique. We have seen them. They are specific and they are dynamic. And this is conveyed by these elements of originality, distinctiveness, and novelty or newness in each of those categories. I'm not going to go into it because of time. It's so painful. I'm not going into all of it. I was talking about branding, the different trademark functions, origin function of trademark, differentiation function of trademark, guarantees the quality of the particular goods. When you put a mark on it, there's a guarantee of quality. It advertises the goods, and of course, it conveys certain left. That's why some ladies' lifestyle function conveys the fact that some ladies would rather wear Hermes products than wear, for instance, any other brand. So those are the core functions that trademark and branding conveys. The entire IP ecosystem. This is the picture. Who benefits? IP owners, IP users, government because of revenue and income it generates. The professions, there's legal professions, there's an accounting profession, there's economists involved because of the issue of asset management, IP asset management. Consumers and the public also benefit. Who loses? Infringers. Piracy, who are the victims? Piracy, counterfeiting, patent infringement. Owners lose because of this infringement, and of course, government as well loses. IP assets are a pool of assets which I've already made mention. I'm going to go here. I'm going to just. This is a bonus I have for you. Managing and protecting your IP assets is very critical for an entrepreneur. You must develop and create the IP, and in developing an IP asset, you must be able to identify what type of IP that I have. Is it copyright? In which case, what am I creating? What am I developing? What am I producing? You identify, is it a trademark? Can I register the trademark? Is it an invention? Can I obtain the grant of patent? And also, there is the element of managing that IP asset, which involves registration, maintenance of that registration. It involves enforcing that particular innovation. It involves a whole lot of activities which are best delivered to you by your IP or your legal advisor. Then you have what we call IP audit, just like the normal audit. Accountants are familiar with the word audit. So there's an IP audit. You want to audit your pool of IP assets. For instance, UAC has like hundreds and hundreds of IP portfolios. They audit them every year to know how much it's bringing in into their network. That's a very important activity for an entrepreneur. Capture its IP portfolio and audit them, and see how it can even improve or add more value to those IP assets. Of course, that leads us to IP valuation. That is a very critical area of IP. How IP are valued, just like how you value your shares in the share market. You value your idea, you know the worth of that particular IP. There is a slide that I want to quickly bring to you. Yeah, this slide. Look at the top 10 global brands. They are not top 10 global brands because of their physical assets. No. They are global brands because of their IP assets. And you can see them on the left-hand side of the screen. Technology industry, beverages industry, automotive industry, leisure industry, restaurants. You can see those global corporations. That is their network, and this is conveyed in their brands, which is their IP asset. And I come back to Nigeria, the top 10, at least as at 2017 statistics, These are the, and it's not because of their physical infrastructure. It's not because of their plants. It's not because of Dangote plant somewhere in Lokoja or Ajaokuta or wherever. No, it's because of the goodwill, the IP assets, the trademarks, the mark, the brand, the intangible assets. Nestle, of course, you know, Nestle has a pool of IP assets. They are the one doing the coffee, they are doing beverages, they have a whole lot of trademarks that they maintain. And the same thing goes at the banking and financial sector. You have, this is excluding telecom. This statistics came when the telecoms was going through the MTN and all of them were going through, so they are not captured in this particular statistic. So it conveys to you, why I brought out this slide is it conveys to you the value of IP assets. And this is it. You have to have an IP strategy as an entrepreneur, especially when you know you are innovating and you are creating value, you are creating goods and services. You must have ab initio from the start an IP strategy or IP policy in setting up. Then you must be involved in due diligence. In other words, if you want to give yourself a particular trademark name, you want to search whether that particular name exists, so you can change the name, so there is no confusion in the marketplace. That's part of due process. Then, of course, you assess in the IP or the IP you know, and all of it. So I'm not going to go for that, but I'm sure we have time to ask questions. But I know the slide will help us in our understanding when we study them in future. Let me stop here so I can have time to take one or two questions before we go. Thank you very much once again, Prof, for having me, and I thoroughly appreciate this distinguished audience for listening, and I hope you take this away as part of one of the things that you have learned in this particular curriculum. Thank you very much.
Thank you so very much, Professor Adebambo Adewopo, SAN, former Director General, Nigerian Copyright Commission. As I said, you did excellently well. You may stop sharing your screen now, sir. So, class, like you, I've thoroughly enjoyed this session on intellectual property and the entrepreneur, and I will now open the floor, the class, for whoever wants to ask a question or say one or two other things. So the floor is open. Just indicate by unmuting yourself and announcing your name. Oladeokin. Oladejo, yes. Who else? Ademola. Excuse me?
Fred.
Oh, Fred, yes, Fred. Who else?
Francis.
Okay, Francis. Okay, we'll go in the order. We'll go from just give me a minute, please. Just give me 1 minute. Yeah, we'll go from the top to the bottom. Maladi, okay. So make it brief because we have just 5 minutes. Yes.
Thank you, sir. I want to say congratulations to our dear prof for this wonderful presentation. Going by the way we carry out research in our universities, I believe that Nigerian universities should have been the richest in the world.
Correct.
Because of the output of our researches. But unfortunately, we are not tapping into this copyright or this IP system, because with what we are seeing today, we just carry out research, and at the end of the day, that's the end. Nobody hears about the research. What can we do about that?
All right. Okay, Alade, okay.
Nigerian.
Okay, yeah, conclude. Alade, okay, conclude.
So that students in Nigeria at the undergraduate, even up to the postgraduate levels, can begin to become serious about the quality of research being carried out in Nigerian university. Thank you, sir.
All right, thank you very much. I take Oladejo now, and who else will follow? Ademola will follow after Oladejo. Oladejo, make it brief, please.
Thank you, sir. First question, sir. If a textbook is revised, a new chapter is added to the textbook, but the title remains, but a new author is conjoined. That invalidates the first copyright. Secondly, sir, I read that trademarks are renewable every 7 years. Is there any justification to that? Thank you very much, sir.
Right, very good. Ademola, Honorable Minister
Yes,
Ademola, take the floor.
Thank you, sir.
Yeah.
Thank you for the presentation, Professor Adewopo. I like
Professor
to ask
Adewopo, SAN. My friend, don't go
Yes,
there. Say that again.
Professor Adewopo, SAN.
Good man, good man.
Yes, thank you, sir. So I like to ask, when you were talking about the legal framework of intellectual property, sir, you mentioned Copyright Act, Trademark Act, and Patent Act. You didn't say anything about Corporate Affairs Commission. I like to know something about that, sir. Then another thing is that who is in charge of International Standard Book Number? Is it the Corporate Affairs Commission or Copyright?
Is that so big?
Thank you, sir.
I've lost them. Don't know where they are.
All right. Sorry, HOD man. HOD man. Sorry, HOD. You're.
I can hear them.
Yeah, HOD man. We're hearing. Can you, please? Okay, man. Fred, take the floor.
Thank you very much, sir. In the submission, we looked at the benefits of intellectual property. We looked at those who benefit, government, owners, and all of
Fred, your audio is not good enough. Yeah, sorry, HOD man.
On the other
okay.
side, that is those who lose. Thank you. So on the issue of intellectual property, we looked at those who benefit. It included the government, the owners, and a list. But when we also went to those who lose, we saw that one of the infringers, those are the pirates, etc. But I also saw under that category owners and government. That's why I'm confused.
Okay.
Why government and then owners would also be losers?
Okay, so you are seeing them on the two sides. Fred, that's what you are saying.
Yes, sir.
You are seeing them on the side of winners and you also see them on the side of losers.
Yeah.
Okay, Francis.
Yes, on the side of winners.
Francis, take the floor.
Yeah, thank you, sir. So I want to ask, in a situation where a company or an individual happens to pirate, imitates the trademark of another company, maybe a prosperous company, and uses it to market his own product. Now, when apprehended, has IP law a fixed punishment for such person or such group, or will be determined by the amount of damage, the length of time he has used that to market his own product, the amount of damage has done to the owner, the company that owns that trademark?
All right. So we are now ready to listen to the answers from Professor Adebambo, Adewopo, SAN. I'm so sorry, we'll have just about 2 minutes to respond to these questions. Over to you, sir, Professor Adebambo, Adewopo, SAN. You may wish to unmute yourself because I muted everybody. You now.
Very quick one. The first question, yes, university research, publicly funded research in Nigeria is a huge resource. It's a hidden wealth that has not been exploited. So the question is a very good question. And I'm glad to know now that some universities are already leading the pack in creating innovation units, IP units, to be able to harness and pull those researches in across field, in arts and science and technology. And the next stage for them would be to actually commercialize them in some areas, or in fact, in some other areas, they could be subject to open access and they will still earn some income. So I agree with you on that. But what to do would be for universities to create these units as part of administering their IP resources. Second question, revised book about new author. Yes, the new author is one of the copyright owners. And of course, in terms of the income or royalty, as the case, it will generate from the new edition where he has joined as author. That is authorship. Authorship is quite different from ownership. in copyright, but this is not the time to go into that extension. But the new author is captured in the revised edition and is entitled to the fair share of the royalties of the new edition. 7 years, the same person asked the question, 7 years trademark. As a matter of fact, when you are registering trademark, the first duration is 14 years. 14 years, then renewable subsequently every 7 years. And of course, in that respect, trademark is said to be perpetual, because for as long as you trade in that particular trademark, you keep renewing it every 7 years. The idea is that, number one, government generates income from your renewal. Of course, you know that that's rent. That's part of government's revenue all over the world. And secondly, it shows that you are trading in that particular trademark. It's very important in that particular brand. When you abandon it, it means you are not renewing the registration. So it conveys a sense of ongoing concern for that business. Third one, CAC. And I've said this many times. You know, one of the most highly generating agency of government will not even be CAC. It will be an IP agency. Let me give you a practical example. When you register a company with CAC, you register that company and you walk away. But that company you have registered may have a huge IP portfolio that you don't go back to CAC to register. You go back to the IP registry to register, and you renew it. So an IP agency can make times 10, depending on the number of IP that you are registering and you are renewing. So a CAC is not responsible for IP. CAC is only responsible for companies. ISS number is administered by National Library all over the world. It's not the subject of copyright. It can be an evidence of authorship, but it's not an evidence of copyright. And there's a lot of case law on that. Benefits and losers. Of course, government loses because it loses revenue. Don't you think so? Just the same way smuggling, can reduce government's revenue from the customs perspective. The same way piracy, counterfeiting can reduce government's revenue. And of course, the creators and the IP owners also lose. So they are both in the plus and minus side. When everything is going on well, government generates revenue. And of course, Nigerian government is not generating half of revenue they should generate if IP is properly administered. Then you have sanction. For IP infringement, there is both criminal and civil sanction. So an infringement of IP, all of the IP, copyright, trademark, patent, are subject to criminal sanctions and civil sanctions. Under criminal sanctions, you can be fined and you can be imprisoned. And that shows the severity of IP infringement. And under civil sanctions, you can claim damages, with general special damages. I will not go more than that.
Oh, thank you so very much, Your Excellency, the future DG of WIPO. I'm sure that all of us here are going to enjoy when it becomes the Director General of WIPO. You are all going to be there by God's special grace. Professor Adebambo, Adewopo, SAN. I'd like to assure you that you are going to be DG of WIPO one fine day. We actually have lawyers in the class. We have lawyers from people who are or students who are in the law program in the University of Burundi, and we have some person here from Nigeria. So, if Madam Debra Oluwaseyi Dairo, if your microphone is working today, we're going to ask you to make the presentation of our plaque to the distinguished professor today. If it's not working, then we're going to get Ibukun Oluwademola to present. Please, can you try whether your microphone is working? Is it working?
Hello, sir.
Okay, it's working. So let's now go ahead and make the presentation of our plaque. So please read. I appreciate Professor Adebambo Adewopo on our behalf.
Thank you, sir, for the honor. Appreciation. On behalf of Lagos State University, African Center of Excellence for Innovative and Transformative STEM Education, a World Bank project, this is to certify that Professor Adebambo Adewopo SAN, Senior Advocate of Nigeria. Facilitated courses ACE 814 and ACE 914 from June 8th to 13th, 2020 by the distinguished Professor Peter Okebukola, OFR, the director, signed. Thank you, sir, for the honor.
Thank you so very much. Now, we are all going to give Professor Adebambo, Adewopo a resounding round of applause. I know you are all muted, but I'd like you to thank him and appreciate him. You see, he has another lecture that is given to a global body at 11. And so for him to have eaten into that time, it shows the love that he has for African students, African doctoral students, and for Lagos State University.